All right, everybody, welcome. It is time for our monthly Work Comp Today. It's where David and I get together with a colleague or a friend from different parts of the country. We talk about impact the news on employers, employees, and independent contractors. And today we are so pleased to have our John Travolta, our Tom Hanks, our John Goodman, a repeat, number two, Ben Gerber coming out of Atlanta with Gerber Holder. Hey Ben, how you doing, bud?
Uh, Thank you guys so much for having me on again.
I am, you share in the same enthusiastic level that David typically does. So we got to get it going, get some caffeine flow. Dave, say something meaningful. How are you doing today?
Doing great.
That's why we keep doing this show, guys. It's just
Yeah.
enthusiasm is just everywhere because that's our
Yeah.
life dealing with work comp and related issues. But what we do, we come to you every month, every 4 weeks or so, and we talk about what's in the news. What are those types of stories, no matter where they are in the country, that typically impact our clients or our future potential clients? Blue collar, white collar, no collar, doesn't matter. They get hurt on the job, and these make it newsworthy. So we want to talk about it and how, from Ben's perspective in Georgia and our perspective in Alabama, how can we better help our clients in these issues? So we have about 4 articles today, as we usually do. Then we're going to do a little comparison of Georgia and Alabama law, and then we'll call it a day in about 45, 50 minutes. So thank you guys for tuning in. Dave, Ben, thank you for being with us today. But before we jump in, Ben, talk a little bit about Gerber Holder and what you guys do so well in Georgia.
All we do is workers' compensation, and all we do is represent those who are injured in workers' compensation, just like you guys do in Alabama. But we limit our practice to only workers' compensation. There is myself, my partner, Tom Holder. We have another partner here, Chris Gifford, and 2 other attorneys that work here. So there's 5 of us in total. A little breaking some news here. We added a 6th attorney, but they will not start until mid-April. So we don't want to announce that yet because they're still working for their current firm. And we are very excited to be able to help those who have been hurt in the state of Georgia.
Excellent. And with our states being adjacent, and sometimes Ben calls David and me friends, so we'll refer cases back and forth, or we may even work on a case or two together. But and later on, we're going to also mention, as we do almost every episode, yes, we are going to mention Amazon, David, so don't worry. But we're going to talk about Will, the organization that we all 3 belong to. And we really just benefit from it in so many ways, not just from our friendships and colleagues and referral sources, but it's a collective think tank of lawyers, that some of the very best lawyers who do employment related matters around the country. And we'll come back to them in a few minutes. But guys, let's kick off with our first article. This one's going to come out of Florida, and it is entitled Miami Beach Police Officers Workers Comp Claim Denied Despite 11-Week Hospitalization with COVID. Now, before we jump into the article, Ben, is there a presumption in Georgia for first responders or for any of those frontline workers that if they come down with COVID and need medical care, that comp is going to automatically kick in? Or is there not that presumption?
There is not that presumption yet. If you would like to help me pass a law, that would be absolutely fantastic. I will tell you, we are actually litigating a number of those cases right now as we speak. We actually have one of our clients, it's tragic, is the wife and the 8 children of a police officer who passed away on July 4th of 2020. And the county is denying the case. He passed away of COVID. And he is a first responder. You know, he was one of the people that were required to continue to work. And yeah, it's a tragic situation. And we are desperately trying to change the law here. But up till now, we've gotten tremendous pushback from the legislature.
Dave, what about Alabama?
Alabama has no presumption in favor of employees who get COVID. In other words, an employee who has COVID has to prove that they got COVID at work if they're going to try to make a work comp claim. Our first responders, our medical professionals, those that work in the medical field, first line workers, they have no presumption that they contracted COVID at work, and they have an uphill battle in this state as a result.
And I haven't looked at the survey, but guys, if either of you know, how many states approximately do have that presumption now? Is there more than a handful?
I would say it's probably in the teens that have some sort of a presumption, whether it's for first responders, medical personnel, or police officers, firefighters.
It's a very limited class if they have expanded.
Well, let's jump to Florida. Let's jump to this Miami Beach police officer. 11 weeks in the hospital battling COVID. It's being reported he may lose his workers' compensation for the time he spent in the hospital, even though others did not. Now, granted, we only have a snapshot of really what's going on in this matter, but Ben, what did you take from this? Is there anything that would help you or help us with this fella's situation? And granted, it's out of Florida. You're in Georgia, we're in Alabama.
What interested me the most about this situation is that he's able to recover and go back to the force. So, I mean, look, Georgia might be different than in Alabama, but a majority of the employers, if you were to settle a workers' compensation case here in the state of Georgia, require a resignation. So it's very difficult to find an attorney if you do not plan on resigning, because we're talking about a limited amount of back benefits he's owed here. Now, the hospital bills can be extraordinary, but I don't know if you can in Alabama. We are not allowed to take fees for any medical treatment in the state of Georgia. So if this police officer has, I think the article said, potentially hundreds of thousands of dollars of medical bills, that would go directly to the hospital, and the attorney would not be able to recover any of that. So it'd be very difficult for that individual to find an attorney. And in fact, just so you know, I think that person's attorney is a member of WILG, actually.
Yeah, I was going to point that out. It's Paulo Longo's law partner, Jeff Bickler. Paulo has been a guest on this program before. So, and Mr. Bickler points out that, and they represent first responders, his firm does. They have hundreds of cases where benefits have been denied for their first responder clients.
It's also to point out that firm helped to get the PTSD aspect of comp for the first responders passed, where we don't have it if it's just mental cases here. But anyway, that's a whole nother discussion for another day. Dave, did you see anything else out of this that we can glean or learn anything from?
You know, they did point out that this police officer was celebrated by the police department when he was released from the hospital. I think they celebrated that on social media. But here he is, needing work comp benefits for COVID, and he was required to continue working during the pandemic, just like so many police officers, first responders. But when they need help the most, when they're sick, then that's when their claims are denied and they're, told to go elsewhere, look for help elsewhere.
Unfortunately, I'm not surprised to hear that, and I'm sure you guys are not either. But it is what it is, and we can, like we do with all of these COVID-related cases, we're not at the end of that story. We're not at the end of these COVID stories. Like you said, I think that Paulo's firm has hundreds of denied first responder claims, and until the law changes in each of our respective states, they're just going to be complete uphill battles. But hopefully one day somebody can find something to be able to help these folks.
You hope the hospital gets involved in this as well, because they don't want to be stuck with, here's the dilemma for this individual. I am sure that he has benefits through his police force, health insurance benefits, but the health insurance is going to deny this, saying it's a workers' compensation claim, right? I mean, that's just pass the buck. So, and workers' comp is going to deny it. So there's going to be all these medical bills outstanding, and everyone's pointing the fingers at each other.
Yeah.
I'm just really curious as to if that's going to be the tipping point. If the hospitals are going to have these hundreds of, probably millions of dollars of hospital bills outstanding, and they're going to be the ones to push the the legislature to do something.
Yeah, I guess it depends on who's lobbying is stronger. All right, guys, let's put a stop into that one, and we're going to move to the state of Virginia. This GRTC, I'm not sure what that stands for. Maybe it's a city worker. Driver was beaten on his route. His work comp was denied, and I guess that's the family saying we are struggling. Dave, did you get a chance to dive into this one? This is just a pretty bad situation for this.
Yeah. So I'll do a quick summary on this one. So you got a bus driver, got an unruly passenger riding the bus, and the passenger threatens to blow the head off the bus driver. And so the bus driver calls into dispatch, and he says, "Can I pull over at this police department or police precinct?" And they said, "No, don't do that." And so he eventually pulls the bus over, and they get off the bus, and that leads to a fight between the bus driver and the passenger. And the bus driver is he's injured very seriously. And as his lawyer says, he's in a fight for his life, and he gets kicked in the head.
Wow.
And so he ends up with very severe concussion-related symptoms with headaches all day long. And so he applies for workers' compensation benefits, and his claim is denied by his employer.
It says he took his mask down and started eating, and I asked him to put his mask up, and he threatened me. Why is that not specifically job related that provoked the attack, Ben?
Fantastic question, Bernard. I don't know. I mean, as you can see in the article, they mentioned willful misconduct, that initially the GRCT said he could have de-escalated the situation at a couple of points and chose not to. Now, in the state of Georgia, that doesn't pass the smell test. That's not going to fly. I don't know about Alabama, but willful misconduct is not going to. He could have taken actions to de-escalate the situation. No, there's really no defense to this one. I would love to be the attorney prosecuting this.
Well, let's talk about willful misconduct and what that means as it relates to a work comp claim and a fight at work for people who are watching who may not understand what that means. You want to define that a little bit and explain that, Ben?
Yeah, I'll define it in Georgia. It has to rise to such a level that there is almost like gross negligence. Let me give you an example. A recent court case, an individual was working on one of these cell towers, and he is taught how to use the harness. Okay. Not only does he choose not to use the harness, but then his supervisor says, "You are not using the harness. You must use the harness this way." And he still says, basically, to heck with you, I know better than all of you. And he gets hurt doing that. Okay. That's willful misconduct. Because that rises to it. He's warned on multiple occasions you're not using the safety equipment either at all or even properly. So it has to be such an extreme level for willful misconduct to apply in the state of Georgia. It is a very, very, very high bar. I don't know about Alabama.
Yeah, same thing. And so if they're found guilty of willful misconduct, or their employer says that they have committed willful misconduct, then their work comp claim can be denied. And it sounds like that's what the employer here, the GRTC, is saying, is that you decided to have this fight, so you therefore are committed willful misconduct, so we shouldn't have to pay you any work comp benefits.
Yeah, although you see at the end of the article, the employer flipped their position and said, "Oh, it's not willful misconduct. It's actually on the insurance carrier now." I loved how they tried to pass the buck to somebody else.
Let me share with you guys as a comparison of a case I handled many years ago that David's very familiar with. Manager of a fast food restaurant was brutally and sexually assaulted by former patrons of the restaurant from the day before, as she was trying to open up the restaurant very early one morning. Ultimately, the case was lost on summary judgment, believe it or not, because the court ruled that the attack was not related to work. The day before, she had kicked out these patrons for setting a napkin holder, the napkins on fire, being disruptive in the shop, into the store. So she specifically kicked them out because of that conduct. They came back the next day or 2 days later and committed this horrible acts. And our local court, or the trial court, ruled that it was not work related. Still bothers me to this day. But how do you equate that to this type of an attack? Isn't it very similar? Yeah. Anyway, it just one of those cases that I would have never have thought it would have been ruled the other way.
Yeah. But the attack on this bus driver seems nothing, only related to the work.
Yeah.
Now, I will say this, if it was the bus driver's own policy to have people masked in his bus, then maybe it would not be work related. But it seems from this article that this was the city or the county's policy, and he was just enforcing county policy.
Yeah, I'd take this case all day long.
Me too.
All day long.
Yeah.
All right, fellas, let's close the book on that one. Let's move to number 3 out of the state of Washington, David's favorite employer. We seem to be accumulating at our firm more and more cases involving Amazon. Ben, right down the street, less than 3 miles from here, they just opened up another one of those big fulfillment centers. I think we now have 3 within 30 to 50 miles of our office. And as large as they are, they may be the largest employer or one of the largest in our state now. I think UAV may still be the largest. They just continually find themselves in bad publicity. The article here says Amazon cited for unsafe work practices at Kent Fulfillment Center, and they face a $60,000 fine. And of course, Amazon disagrees. Here's my question before we jump into the article. Ben, do you guys have a lot of look at a lot of Amazon related cases? Do you have fulfillment centers, I assume, in the metro area?
Yes. And I will tell you this, I'm not sure it's ethical because we consider how much my wife and daughter order on Amazon. I think they are creating some of those on the job injuries. But yeah, we're seeing a huge uptick in warehouse fulfillment related cases. Yes.
Yeah, we just filed a lawsuit this month against them. And I think I'm currently looking at 4 or 5 right now. Dave, what about your practice?
Amazon is many employees that they have. I think they're taking a hardline approach on work comp claims, and they're not looking at the beneficent purpose of these work comp acts in our different states. And they're not. I think they're taking advantage of employees, and they're a bad actor for a lot of work comps. What I'm seeing.
If I could jump in real quick.
Yeah.
And to piggyback on what David said, I don't think they're looking at state by state at all, because Amazon in the state of Georgia, they have nurses in their warehouses. And if you get hurt, they require you to report your injury to a nurse who will then provide first aid care. That is not required, nor is it looked upon favorably in the state of Georgia. You're allowed to pick a doctor right away. Now, I know some states, especially like in Texas and Oklahoma, you have to report it within a certain time period, and you have to report it to a certain individual. And they just carried on that practice, it seems like, throughout the United States. And it's actually a hindrance to Amazon in the long run, because they direct care in the state of Georgia. And if you direct care, you lose control of medical treatment in Georgia.
They seem to have overtaken Walmart in a hurry with the sheer volume of cases that at least come through our office. Anything else out of this other than we're just kind of crapping on Amazon for a few minutes?
I will say that I find it difficult for Amazon to argue that the state is wrong when this is what, the 3rd or 4th violation in the state of Washington in a short period of time. So this is obviously a pattern and a practice. So I don't mean to crap on Amazon, but I really do mean to crap on Amazon. You know,
if the facts are there, the facts. That's what the facts are.
You know, and it's like you just said, Ben, it may be that their numbers crunchers just said, we just have to take some of this as loss. But considering what we're bringing in, Anyway, I guess we will bookmark Amazon, as we know they'll be back next month in our thoughts and prayers. I think in the last 2.5 years of doing this show, I suspect they've been on the show about 80% of our time here. The next article really, it comes out of California, but I really want to focus more on our respective practices, because the average person who calls us, and I suspect, Ben, it's similar for you, they haven't had any prior injury work comp claims, or if they have, maybe one or two in their work history. This is what we do for a living. We have to explain, we have to give them the facts, the law, and how all this pertains to their case. Why can't I have a workers' comp case and a personal injury case against my employer? Why do I have, on the other hand, why is it I'm able to pursue a case against the driver who hit me from another company, and I can maintain a work comp case against my employer? And I realize we could spend the entire hour comparing how all this works. But Ben, I want to start with you, and then Dave, you can chime in. When you have a potential new case, which I know you talk to folks every day, Ben, how do you explain to them, this is Georgia law, not Alabama, not other states. How do you explain, here's the kind of cases that we may have, we got to do some investigation, but you need to just kind of bear with me and let me explain how all this works. So I guess you can answer it any way that you want. I just want to be able to share how lawyers talk to their new clients or potential new clients about this.
That's a really difficult discussion to have. I actually had a case today, and I talked to a woman today, and she said that, let me tell you the facts. And this, she was standing, she works in like a medical facility, and they had somebody come build shelves. And the person that built the shelves didn't know what the heck they were doing, and all the shelves crashed down and hit her. And she said, I don't want to bring a workers' compensation case. I want to go after the individual who put these shelves on. Clearly these shelves were not anchored to the wall, or they were done horribly. I said, all right, well, let's look at this. Who installed the shelves? She goes, oh, we just had the janitor do it. And I had to say to her, well, if you know, because the janitor did it and he's a co-employee of yours, you're stuck in workers' compensation. Yeah. As crazy as this sounds, if they had hired a third party to come in and that person had built the exact same shelves the exact same way and they fell on you, you could have had a third party claim. So, you know, I know we're talking like, and to the average person, they're like, I don't care who built the shelves. They fell on me because someone built them poorly. And we have to explain and very carefully, you cannot bring a workers' comp. You can only bring a workers' compensation case in this instance because it was a co-employee. And that's very frustrating for lots of people to hear. You know, do I want to give them a history lesson and go into the grand bargain and why we do it? I mean, they don't want to hear it from me. They just want to, just want to hear they can or cannot sue their employer.
Dave, how does your conversation go with an Alabamian on this same topic, same scenario Ben just presented us?
I could pretty much take exactly what Ben said and use that same advice in Alabama. It's identical to what in Alabama, and I've had that same conversation, Ben, where it's like, sorry, you can't sue the coworker, but if the third party had built those cabinets and shelves, then yeah, you'd have a case against the third party. Yeah.
Stay in that scenario, but let's change it just a little bit, fellas. Let's say the employer did hire a cabinet making company and they came in and built the shelves, and the same thing happened, the injury. Now, Dave, you're pursuing both cases, but here's where we're going to get deep in the woods for like 10 seconds. Talk about subrogation between the two, and what is subrogation? How do you explain to your client you can't fully double recover for both entities, even though the law may allow you to pursue those claims?
So in that situation, if the injured worker receives medical treatment and that medical treatment is paid for by work comp, then the injured worker has a case against the contractor and recovers money from the contractor, then work comp has the right to be repaid money that they spent on medical care and work comp benefits paid to the injured worker while the injured worker was off work. So in other words, work comp's going to get some of its money back from the injured worker in the form of what's called subrogation. So the injured worker can't receive a double recovery in that instance.
Ben, do you have similar?
I'm going to disagree. It's not a double recovery. It is a recovery on two separate claims, because in the state of Georgia, unless you are made whole in the personal injury case, there is no right to subrogation by the workers' comp carrier. So let me give you that same example. You know, the third party comes in, builds the shelves, and it falls on the individual.
Yeah.
And they have all their medical treatment paid for by workers' comp. Workers' comp does not have an automatic right to subrogation unless that individual is deemed to be made whole in the personal injury case, which is a very high standard and very difficult to do, quite frankly.
I was going to ask you, can you give us a quick summary? What does made whole mean in Georgia?
Yeah, I will tell you, in all my years of practice, I've only had a handful of cases where the individual was made whole in a personal injury case. And typically that means, because, you know, and let me tell you why. In a personal injury case, 9 times out of 10, you are negotiating a settlement of some sort.
Yeah.
And if you negotiate a settlement, you have to give up something to get something, and therefore you're not being made whole. Now, if you go to a trial and you win, then in theory you could be made whole in that situation by a jury of your peers. But it's very, very difficult to prove that one is made whole.
Yeah, when you do those negotiations, there's a compromise. You give up a little bit, they give up a little bit, and then hopefully you meet somewhere, not necessarily in the middle, but you are giving up a little bit of what maybe potentially you could get at a trial.
Let me ask you guys this question, Bernard,
Yeah.
You and David this question. If you have how do you talk to an individual who was a passenger in a work vehicle, and it was the driver in the work vehicle's fault that caused the accident? This happens quite often. And they come to you and they say, I want to bring a workers' compensation case because I got hurt on the job, and I want to sue the person who was driving. I don't know the person that was driving. They were just a coworker I'd met the day before or whatever, and they were at fault for the accident. How do you deal with that situation?
Where's the insurance coverage? And my question to answer that in part is, if you sue that driver individually, their personal health, auto coverage may not be there because that's a commercial vehicle that they're driving. So the employer, the owner of that vehicle, that's where your coverage is going to be. So you could sue that driver, but how are you going to recover from that driver? I mean, I know that's part of the equation here.
Yeah.
Dave, something else you can throw in?
I wonder if the guest passenger statute in Alabama, which is unique to Alabama, I think might be a bar.
Oh, it's horrible.
Yeah. Not to get too deep in the weeds on that, but I don't know, Ben. I mean, you're looking at suing your co-employee there, and I don't know that would work in Alabama, because what's the difference in that co-employee driving and causing a wreck and that co-employee swinging a hammer and hitting the coworker in the knee and causing injury? Still think it's a co-employee situation, and you know, unless your co-employee was wanton and intentionally tried to hurt their coworker, I think the case is going to fail.
It would fail in Georgia, and that's a very, very difficult conversation to have with an individual.
Yeah.
Yeah. Well, guys, that's our 4 articles for this week. And with our last several minutes, I want to do a little comparison of Georgia and Alabama law, and Ben, how you and your firm approach certain conversations, as we've been talking about the last several minutes. And then Dave, we'll just go back and forth. How long will my case take? It's always one of the first parts of a conversation with a potential new client. How long is this going to take? When am I going to be finished with this? When do I get my money? And Ben, I know every case is fact specific, but how do you approach that with somebody who's just met you? You're trying to build that trust. They've just hired your firm. They're looking to you to guide them through this process.
Yeah, it's a question I think we're asked on every single intake call that comes in. And I'll give you the specific, I'll give you the answer I give them. I say the typical workers' compensation case in the state of Georgia takes anywhere from 6 to 9 months. That's just the average. Okay? Each case is different. Look, in Georgia, we're sort of on a rocket docket. From the time we file a hearing request, and remember, we are an administrative court. We are not we're unlike Alabama. We're going to have a hearing within 30 to 60 days set. Now that hearing is not going to go forward on the first setting, and it might get postponed 30 or 60 days. Mm-hmm. But you're still talking about a time period there of 120 days, which is what, 4 months. Now, that's the generic, okay? Specifically, it all depends on how you're doing medically and what needs to be done on the case.
Yeah.
And people I find that people like to know what's the average, and then we'll get in the weeds, and I'll give them a game plan. A typical ankle injury is different than a back injury. Mm-hmm. A surgical case is different than a non-surgical case. It's very difficult to give these people an answer, but they deserve some bit of expertise that we have on how long a typical case takes.
David, when you have that conversation, don't you have to preface it by saying, well, it depends?
Absolutely. Because sometimes people may become our client within a day or so after they got hurt on the job, mm-hmm. right? And they haven't had surgery yet. Or they may come to us after reaching maximum medical improvement and gotten a settlement offer, and we're ready to negotiate. So we may represent someone for a couple of years, depending on when they come to us, or a couple of weeks if their claim is ready to be settled. Now, I'm going to go back to something I mentioned about maximum medical improvement, or MMI. So that's a really important part of any client's case, because especially if they come to us and they're still treating. So we're limited in what we can do as far as resolving the claim until they reach maximum medical improvement. And that's the point in time where the doctor says, you're about as good as you're going to get. There's nothing else the doctor can do to lower or lessen your degree of disability. And MMI is typically the point in time where they're going to get returned back to work or have an FCE, and we'll know what their restrictions are. So everything we're doing is working up towards MMI. And then after they get to MMI, then we're in a better position to evaluate for settlement, or to go back to work, or to file the lawsuit.
And Ben, that's usually when we get to that MMI, that's maybe our 60 to 120 day window I like to look at. But you're right, every case is fact specific and can be a little bit nuanced. For those of you who are just tuning in, for those of you catching us on replay later, I want to welcome you. This is our monthly work comp today, where David and I and a guest this month is our buddy Ben out of Gerber Holder in Atlanta. We talk about work comp. We talk about independent contractors. We talk about anything where somebody gets hurt on the job or job related. We even talk about Uber and DoorDash and just those, what was commonly referred to as the gig economy workers. We talked about that for several months in a row when this was a real hot topic in late 2021, earlier in the last year. But as we do every month, we run through a bunch of current newsworthy articles. We do a little comparison of the states of our laws in Alabama with our guests, and just to try to educate folks who may be watching us for the first time, or maybe thinking about hiring a lawyer and want to learn a little bit more. We hope we're doing a good job of sharing a little bit. We've got a few more minutes left in this month's episode. Here's the next one. And boy, if we don't get this, as soon as that case gets settled or agreed upon, when do I get my check? Dave, take us through our scenario, how our practice, what Alabama law and our firm's practices, so clients have a good idea of that window of time, because they want to know when they're going to get it. And they also kind of want to know, why isn't the check coming directly to them from the insurance company?
Yeah. So in Alabama, we have our settlements approved either in court or with the State Department of Labor through the Ombudsman program. So typically, if we're going to court or we're in person having a settlement approved, the insurance company lawyer will bring the settlement check to us in person, Or if we're doing it over the phone, then the check will be either delivered or mailed to our law office. Now, when does the client get the check? Well, so the check is typically going to be made payable to our law firm and to our client. So that's why we can't just give the client the check, because our name is on it as well. So we're required to put that check, that settlement check, into our law firm's trust account. We have to allow that check to clear the bank to make sure it is good money. And typically there's never a problem, but sometimes there is. There can be an endorsement, a signature issue. So we have to let the check clear, make sure it's good. Then our client's check will be ready typically within 5 to 7 days of deposit.
Mm-hmm. Ben, we've also had occasions where the check never arrives and we have to file a motion to compel or enforce settlement with the court 6 weeks after the fact. I just had to do this, file my motion on a Monday, and lo and behold, the check shows up on Wednesday. So,
well, let me ask you, are there any ramifications for that?
If we got to the hearing stage, there could be. But the 2 times I've done it this year alone, the checks magically show up within a matter of a couple of days. And I just think it's some things that shouldn't be going on, improper delays behind the scenes. Ben, what about your procedures? How do you guys go from settling your matter to getting your clients their money in a timely fashion? What's typical for y'all?
Yeah, we actually have a much more streamlined system than I think in Alabama.
Imagine that.
Once again, Georgia beating Alabama.
Okay, there's one.
Every single settlement has to be approved by the State Board of Workers' Compensation. In fact, every dollar over $100 that an attorney receives in a workers' compensation case has to be approved by the State Board of Workers' Compensation. Mm-hmm. So once you submit a settlement agreement to the State Board of Workers' Comp, it's typically approved between 24 and 48 hours after it's submitted. At that time of approval, and the attorneys both get, both the defense attorney and the claimant's attorney get notification of that approval. The insurance company has 20 days to issue payment. If payment is more than 20 days late, with the mailbox rule applied, then the insurance company owes a 20% penalty on that settlement. So I tell all my clients, and you want your check either right after the case is settled, meaning the check is FedEx to us the next day after approval, or you want it on that 25th day, because then you got 20% more. The checks come to our office, and the checks come to our office because we need to be aware of when the check is received, because if it's outside that period, the individual is entitled to 20%. And if it goes directly to the client, we have no way of knowing when the check was sent or any of that kind of stuff. And typically, in 90% of the cases, the check is made out directly to the client so they can come pick up that check as soon as we receive it. We notify them immediately upon receipt. Now, the way we handle it at Gerber Holder is the client signs a settlement statement about how much they are going to receive when they sign the documents for the settlement, so they know exactly the money coming in, so they can deposit their money immediately upon receipt of funds.
Yeah, we have our own in-house disbursement sheet that itemize where the money is going. What about direct deposits? Do the insurance carriers in Georgia do direct deposits or wire transfers to your firm, or are they hard physical checks still?
So there are direct deposits for weekly indemnity benefits to the clients. Mm-hmm. There are no wire transfers when it comes to settlement.
Dave, are you starting to see more direct deposits on the weekly checks? We don't get, just similar to you guys, Ben, the settlements are paid in a physical check. And that's where some of this delay, it's lost in the mail, or we sent it, whatever, they make all those excuses. But Dave, I'm seeing more direct deposits with the weekly checks.
Yeah. And it's certainly, most clients like that because we're not worried about the mail. Speaking of direct deposits, I got a call from a client today who says, work comp put $6,300 in my account. Can you check and see what that's about? And it sounds like they were advancing payment on his physician assigned impairment rating, didn't bother to let us know
I was
about
getting
it.
ready to
or
say
him.
bypassed you.
Yeah, yes, even though I'm counsel of record, and gave him $6,300, and I assume it's based on his impairment rating.
Ben, we also have clients asking more and more if we can wire their net proceeds to them. They're happy to pay the 30 or whatever the bank charges to process all of that. Are you permitted to do something like that with your clients' funds if they run through your firm's trust account?
Yeah, I'm uncomfortable with that. I don't want to have to deal with putting the funds into my IOLTA account, my interest-only legal trust account, and then sending it out to the client. So we have avoided that. Now, we have no problem FedExing a client a check if that's what they so desire, but not actually wiring a check.
That's interesting because our clients' funds have to go through our trust accounts, our IOLTA account, so that way. Well, fellas, that's all of our topics and subjects, less one thing. As we try to do is I want us to, again this month, is to continue to educate our fellow practitioners about the workers' injury law and advocacy group that we all have belonged to. Y'all longer than I, but we're on the board of directors and just have found so many benefits. And Ben, I'm going to let you lead off with why will, if I'm a practicing work comp lawyer in Minnesota or anywhere else in our country or other countries, why would I want to be part of a larger collective organization like this?
Well, for a number of reasons. The first reason is that the pooling of brain power has really helped affect workers' compensation laws for the good in the country. You're in Alabama. There was a couple of years ago, there was a constitutional challenge to the laws in Alabama. I know that the individuals who brought that claim in Alabama had nationwide help, quite frankly. And let me give you a real specific example, and it has to do with your firm. This morning, I was texting with Bernard about a certain case that we have. An individual works in the state of Georgia, got hurt in the state of Georgia, and we have a claim in the state of Georgia for that person. They went back to work for that employer, and they were working in Alabama, and they got hurt. Mm-hmm. And I did not know what the statute of limitations is in Alabama. Let me tell you what it is in Georgia and how it's different. In Georgia, you have 2 years from the receipt of the last indemnity benefits paid, which means a weekly check, or you have 1 year from date of accident if no indemnity benefits are paid, or you can toll the statute, meaning you have extra time, if the insurance carrier pays for medical treatment. You have 1 year from the last date of payment of medical treatment. So I thought I had plenty of time to file a claim in this instance. And Bernard, you told me something completely different, which both surprised me and was very helpful for me. And what was that?
That ours is a different statute of limitations. Medical care does not factor in the statute. And almost similar to Georgia, it's 2 years from the date of the accident if no comp benefit checks are paid, or 2 years from when those checks are stopped paying. So that can push out the statute based on the weekly or biweekly workers' compensation checks being paid. And that's how Alabama differs from the way Georgia treats its statute.
And another reason to join Willig is that it provides you with resources throughout the country. It is our job as lawyers to assist our clients. And our firm has a lot of clients who are truck drivers, who are driving throughout the country. And, where is jurisdiction best for this individual? Where can they bring the claim and where they cannot bring the claim? And we have talked to multiple lawyers throughout the entire country saying, if they were to bring a claim here, it would be worth this much. If they were to bring a claim in this state, it'd be a different amount. Example, real quick. I think it's Wisconsin has strict caps on what the spouse of a deceased worker can receive. It's limited like at $100,000 or give or take. In Georgia, we don't have a cap like that. There are different rules for that. So an individual was hurt in Wisconsin or Minnesota, I forget which state it was, quite frankly. I called up an attorney there, we talked about it, And he said, you really need to bring the claim in Georgia because it's most beneficial for the spouse of the deceased individual. So just little things like that are just so invaluable in the practice of law.
David, how quickly do you get responses if you put out a query on our listserv and it involves other states? You know, most lawyers historically are very territorial. They don't want to share their knowledge. They want everything.
Yeah.
How quickly do you get response?
Oh, the responses are almost immediate, and we're getting information from some of the best work comp lawyers in the country. I represented a truck driver, Ben, last year. It was an Alabama work comp claim. She lived in the Northeast, but got hurt here, so I was able to help her with an Alabama work comp claim. It wasn't a big work comp claim, but we, able to do some good for her, get her a settlement. But we were talking about third-party cases, and she got hurt at a truck stop on the East Coast, maybe in state of Maryland. And so I needed a lawyer for her so he or she could investigate whether she had a third-party claim because she slipped and fell on somebody's property. Well, through Will, we were able to find her a really good lawyer, and she ended up getting a $750,000 settlement out of that accident in that case. So again, just because my membership in this organization was huge benefit to my client. So.
One more thing that's very important. Doctors, right? People are transient. We have lots of people who are hurt here, and when they get hurt, they can't afford to live where they were living anymore, and they move back, home. And if home was in Chicago or New York, and they're allowed to continue to treat for workers' comp, and you have to find a doctor that will help that individual wherever they move to. You can just put that information out on the listserv, and within minutes, nanoseconds, or very quickly, you have a plethora of doctors who your client can treat with.
The network is amazing. We could talk about Wilg and its benefits for the end of time. I put a link in the show notes to the website. Contact Ben, contact David or me. Very easy. I'll put Ben's website as well as in the show notes. Fellas, I want to thank you both for spending some time sharing your knowledge, your expertise, your wisdom about all of these cases and how this is the meat and potatoes of what we do every day and have been for many years. So Ben, Bud, thank you as always for pinch hitting this week and this month and stepping in.
Speaking of pinch hitters, let me throw this at you real quick. Freddie Freeman left our beloved Atlanta Braves because the Braves did not offer him a 6th year. Okay, let me put this scenario out. Let me ask you guys this question. In the state of Alabama, can you contract outside of workers' compensation? In other words, can you have a contract that says you cannot bring a workers' compensation case?
I don't think that you can.
In Georgia, you cannot do that.
That's void. No, it's void against public policy.
Okay, same in the state of Georgia.
Yeah.
If the Braves had offered Freddie Freeman a 6th year when he was 38 years old, and let's just say hypothetically Freddie Freeman got hurt at some point during that time, the Braves could have said in that 6th year, we no longer have light duty work available for you. You must go out on workers' compensation. Instead of paying you $30 million a year, we will pay you $675 per week. And therefore, the Braves could have saved $29,965,000 on Freddie Freeman's last year. So the Braves could have had Freddie Freeman if they had only applied workers' compensation rules to his contract.
Just to throw a little bit of a wrench, I don't think the collective bargaining agreement would have allowed for that.
But null and void in the state of Georgia. You cannot contract outside of workers' compensation.
Wow. Crazy.
Ben, thanks for not beating us over the head with the fact that Georgia won its first national championship in football in 41 years. So thank you for limiting that.
I appreciate the backhanded compliment. I just know Georgia has won a national championship a full, gosh, when's the last time Alabama won one? It wasn't before Georgia. It was before Georgia, right? Yeah.
All right. You've each gotten in your own barb. We're not going to allow this to devolve online. This is going to continue even after we sign off. Trust me, folks. Again, Ben, thank you, bud, for joining us on Work Comp today. Dave, it's always a pleasure to see your smiling face and your contributions. We will be back this time next month with another guest, another episode, another group of articles. Inevitably, Amazon will be there. Hope you'll be there. Y'all have a good rest of your week. Be